Afternoon, everyone. Thanks for joining our last webinar of the year. We've had a few this year, and we plan to continue the webinars through the next year. I think we're ending off with the best one, which is the best and worst legal cases for 2023. We've got a great panel on our hands, and I'll discuss them shortly. But just to give you a bit of background or information on Hunt & Hunt, if you don't know, Hunt & Hunt was started in 1929, and our tagline is genuine people, practical solutions. And I think it kind of explains it itself, but we try to provide practical advice. We're not just about billable hours, and we try to understand your business and try to help you with solutions through it. Our panelists today are a great bunch of lawyers. We've got Jeremy, Olivia, and Katharina joining us today, and the webinar will be split into different sections of law. We all focus on our specialist areas, and we hope the cases are interesting. We will chat about IP and trademark cases, employment cases, criminal and estate cases, and lastly on unfair contract terms today. I'll be kicking off based on the IP and trademark cases, and I'm just going to outline a few of the interesting cases that were dealt with this year, and give some nice examples just so you understand what IP and trademark rights are, how these companies or people utilize their trademark rights and IP rights to obviously stop others from infringing their rights. The first case was quite interesting with the recent ruling in the McDonald's and Hungry Jack's case. Hungry Jack's launched a new item named Big Jack, and I believe it was Mega Jack, in competition to McDonald's Big Mac. And in this case, McDonald's actually lost the trademark infringement case, but won the misrepresentation battle based on consumer law. Hungry Jack's claimed that their burger contained 25% more Aussie beef in their commercials and lost actually on this ground. The next case was Katy Perry versus Katy Perry. Katie Taylor is an Australian citizen who had a fashion line and actually registered a trademark for Katy Perry. Katy Perry, the music singer, obviously started to sell her items, her clothing items, and obviously wanted to trade within Australia. And she actually tried to apply for a trademark for Katy Perry, which was refused. Katie Taylor, the fashion designer, actually took it to court and was awarded damages for the use of her brand in Australia. So even though you can be an international celebrity and actually might have rights to your name, it doesn't mean that you can actually trade with certain goods in certain territories. So celebrities, musicians just like Katy Perry, the singer, will actually go and register their trademark or their brand around the world in each country they intend to go and perform in or sell items or clothing items, which obviously are branded on clothing. Her name will be branded on different clothing items. The next case was Boost Mobile versus Optus. In this case, Optus unfortunately had another low blow here, in that they utilized the brand Boost in terms of a new feature on their mobile platform, which gave it increased internet speeds. Boost Mobile took them to court based on their Boost trademark and actually won and were awarded an injunction against Optus, and Optus actually has to pay damages to Boost for the use of their trademark. It's quite interesting, and I'll touch upon this a little bit later, but Boost could be described as a descriptive trademark. So trademarks, in order to trademark a brand or a word, it has to be unique. It can't be commonly used in an industry. And there's certainly an argument that a lot of telecommunication providers and internet providers use the word Boost, but somehow Boost Mobiles managed to still hold onto their trademark and enforce their rights against the likes of Optus. And I'll come back to this later with another example of another case where there was a bit of a descriptive trademark that was used. The last case on that slide is the Pokemon case. So Pokemon, if you don't know, is a character and is actually owned by Nintendo. And they have rights to obviously that animated figure at the bottom of the screen there. So Nintendo actually picked up that there was another entity registered in Australia called Pokemon Pty Limited. They actually had registered a business name for Pokemon Pty Limited, even though they weren't entitled to the use of the Pokemon trademark. So yes, you can go register. I can go register a business name now for Nike Clothing Pty Limited, and the Australian Business Register will actually let you register that name. I can go register McDonald's Burgers and Fries Pty Limited, and there's nothing that stops me from doing that. Obviously, McDonald's or a Nike can go and launch court proceedings and stop you from using that business name, but ASIC doesn't actually do any vetting or any checking on whether you're entitled to that name or not. So you actually got to go and enforce your rights against a third party that does register the business name. But in any case, I'm veering off the point in this case, this Pokemon case. This third party that's unrelated to Nintendo actually intended on releasing they were a cryptocurrency company, and they were intending to release a non-fungible token with the use of the Pokemon, the animated Pokemon figure. And Nintendo managed to get an injunction order against this illegitimate or unlawful company, and stop them from releasing this NFT. So in the trademark and IP space, it's actually, it actually protects you in the digital area now as well, because IP and trademarks are now extending further into the digital space and not just on physical products. The next interesting case was the agency versus the North Agency. Now, the North Agency was an independent real estate agency based in the Northern Beaches here in Sydney. And the agency, which is an ASX-listed businesses, actually took them on and tried to get an injunction order against them and the use of the name and the brand. And the agency, the listed business, actually lost the case. Now, I'm jumping back to that descriptive where a trademark needs to be unique. Now, the agency for real estate services, the word agency is actually not unique, and obviously it's used by a lot of third parties. Now, the issue with it is that they've actually adopted a very descriptive brand, and it's going to be very difficult to stop others, just like the Northern Agency, from using the word agency. And that's why they actually lost the case. But more interestingly, I've put up a few pictures here. The North Agency certainly, they're borderlining, passing themselves off as the agency. If you have a look at the different domain and the realestate.com.au pages, they certainly look a little bit similar. And interesting enough, the logos on the right-hand side, the court found that they were quite distinct and that they weren't similar, which is quite interesting. So yeah, when adopting a new brand or adopting a company name, certainly try to come up with something that's unique and distinctive so you can stop others, even though they might be slightly passing themselves off here, in terms of the coloring and the branding. It's always better to have a unique name or a unique brand to stop others. It makes it much more clearer and easier to do so. I've listed here a couple of examples of trademarks that were found to be similar. The first is this Visor versus Rebel Trading. You could see that this unique V logo was adopted in the Rebel Trading logo, and obviously that was found to be similar. Kyle Foods, obviously the two brands are very, very similar there, especially with the name Kyle both being used. The Lens.me and Lens.me, obviously, that's quite simple. It shows, because basically the test is with IP and trademarks is whether the member of the public will be confused when looking at the two brands. Be confused into believing that they're associated with each other or they in fact are the same company. So certainly that Lens.me and Lens.me is very, very similar. The next example is Acorn Grow versus Acorn Capital. Slightly different logos. Obviously, the word acorn might be unique in terms of financial services in that kind of investment industry, and obviously they might be entitled to the rights and the use of acorn, and that's why they were managed to stop the other brand. Another example there is Moore. This is obviously the accounting and auditing service versus Moore's. They were found to be similar. Little Freddy versus Little Freddy, Aleve versus Alvive, and then T20 versus T2. Those brands were all found to be similar. Some other ones were TikTok versus TikTok, Oswilly versus Oswald Pro, Brown Nose Day versus Red Nose Day, which is quite an interesting one because they're both for charitable services, and I'm not too sure why you would call your charity Brown Nose Day. There's a bit of a bad connotation to that name. The last one there was Volvo versus Volvo, both for car fitment parts and obviously vehicles. So definitely very, very similar, those two. And jumping across to social media cases. So IP, like I said earlier, extends to the kind of the digital era now. And we deal with a lot of social media cases in terms of taking down Facebook pages and social media posts and pages. And this was quite an interesting case in that, obviously with the World Cup going on, many Twitter users were actually posting footage of the World Cup that happened and obviously key moments. And FIFA was able to actually get some of the video images taken down from Twitter and enforce their rights. Obviously, they've got rights to the footage and the copyrights in the footage, and hence that's why they were able to take it down. So in order to take down any kind of post or footage, you need to be able to prove that you have rights into the IP. We often deal with it more on a trademark-related basis, where another fraudulent company has registered a trademark, Facebook or a Twitter or Instagram page, or there's a fraudulent logo or unlawful use of a logo, and that's been posted, and then we would have to prove that the company has trademark-related rights to that logo or that name. And that's how we actually get the page removed or the post removed. It's very difficult if you don't have any kind of proof of ownership. So if you've just been trading with your business name and you don't have a trademark in place, and the third party registers a Facebook page that's identical to yours and identical to your name or your business name, it's very difficult to actually get that page taken down. Even though you might have been trading for the last 30 or 40 years, you need to actually have the trademark rights, and we actually have to upload your trademark certificates to prove that you have rights to that name. So just trading with the company name is actually not good enough these days. And jumping to domain names. So domain name is basically your website internet address. And these were some of the key decisions that just illustrate why trademarks and IP are so important. So third parties actually register domain names to try and reap a benefit from it for different reasons. One, it can be a third party or an individual that quickly registers a domain name like Gucci.au and then tries to sell it back to Gucci, the business, and make a profit out of it. Or it can actually be third party or competitor businesses which will register a website or a domain name and use it as to try to get hits to their website and redirect it to their business. So in these cases, we can actually assist clients in obviously getting that domain name or website taken down and get control of the domain name. And how we would do that is, once again, rely on the trademark rights. We have to prove that you actually got ownership in the name. And in these cases, these businesses were entitled to actually get the domain names back or get them deleted. And there's some famous brands there, Metzler for tires, Gucci for fashion items. The President's one is quite an interesting one in that I put that there, is that often there's generic domain names or website addresses that are registered. You can understand for something like cooldrink.com or cricket.com, who's actually entitled to that domain name. And in that situation, it'll be on a first come, first served basis, because, if I register, or say Nike wants to register footballclothing.com.au, there's nothing stopping Adidas from registering that. So no one's actually got trademarks to that domain name. So in that case, in the president.com.au case, the third party actually lost their case after lodging the complaint because they couldn't prove that they actually had rights to President, the brand President, because, like I said, anyone can register it as long as you can prove that it relates back to your business in some case. And we'll hand over to Olivia now. Olivia will be speaking about employment cases.
Thank you, Ty. Good afternoon, everyone. My name is Olivia Shevington, and I will be taking you through some of the interesting cases that we've seen in the employment law space this year. The first case is, let me change my slide. First case is CCIG Investments Proprietary Limited and Schockman. And this was a case that went all the way to the High Court, and it involved a dispute between an employee and their employer. The background being Mr. Schockman, he worked at Daydream Island Resort and Spa in Queensland as a supervisor, and he was required as part of his employment contract to live on the island. His employer, CCIG, provided furnished shared accommodation for Mr. Schockman and another one of their employees, Mr. Hewitt. On the night of the 6th of November in 2016, Mr. Hewitt went out drinking at the hotel bar, and he returned early the next morning heavily intoxicated. At approximately 3:30 a.m., Mr. Schockman was awoken in a distressed state and unable to breathe as Mr. Hewitt was standing over him and urinating on him, and Mr. Schockman was inhaling Mr. Hewitt's urine and choking. Mr. Schockman then suffered a cataplectic attack, which is an episode that involves the sudden loss of voluntary muscle tone triggered by extreme emotional distress. He also then suffered PTSD and developed an adjustment disorder as a result of this incident. Mr. Schockman then commenced proceedings in the Supreme Court in Queensland, seeking to recover damages from his employer for these injuries suffered as a result of the incident. Mr. Schockman claimed that CCIG was vicariously liable for what he called the negligent urination of Mr. Hewitt, because that act was done in the course of Mr. Hewitt's employment. Mr. Schockman's claim was dismissed by the Supreme Court, but then upheld by the Queensland Court of Appeal, leading CCIG to appeal to the High Court. In deciding this case, the High Court ruled that an employer is only liable for an employee's wrongful act if it occurs within the scope or the course of the employee's employment. The court then emphasized that although an unauthorized, intentional, or even criminal act could be committed by an employee within the scope of during their employment, the employer will not be accountable for every action chosen by the employee. And where that conduct is so remote from the employee's duties as to be entirely unrelated to the employment, the employer will not be liable. And in this case, the court found that Mr. Hewitt's negligent urination was not committed during working hours and was within the employee's accommodation rather than in their workplace, and was therefore not remotely connected with the employee's duties, and therefore found that CCIG could not be liable for that negligent urination. Now, the facts of this case are obviously a little bit unusual. However, the High Court's decision provides a useful example of the circumstances that might fall outside of the scope of an employee's employment. However, it demonstrates that this will not always be clear-cut, as even the Court of Appeal in this case was willing to uphold Mr. Schockman's claim and find the employer vicariously liable. It provides a timely reminder for employers to always provide their employees with clear employment contracts and position descriptions so that the scope of their employees' employment is clearly defined and clearly understood. Employees should also ensure that regular relevant workplace policies are in place, and these policies can set the expectations of their employees clearly. This is particularly important in employment that requires travel or on-site accommodations and that sort of thing, where the line between work and home can become blurred. Two other cases that happened this year are the cases of Adam Thompson and Ventia Australia and Martin Pelly and Ventia Australia. These decisions involved very similar circumstances and involved employees that were employed by the same employer. And in these cases, Mr. Thompson and Mr. Pelly were firefighters, both employed by Ventia, and they both made posts to a private Facebook group that was set up by another employee titled Sicko's Video Sharing Group. Now, these posts that were made in this group ranged from pornography and videos obtained from some of the members' OnlyFans subscriptions to racist memes and other material not suitable for work. Some of the more sexually explicit posts were shared by Mr. Thompson while he was on duty at work, as well as outside of work hours. And Mr. Pelly also shared some racist and derogatory memes and images during working hours, but Mr. Pelly did not circulate any pornography during working hours. Ventia then alleged that the firefighters had both breached their workplace policies, including the bullying and harassment policy, the code of conduct, and the social media policy, and consequently terminated the employment of both of these firefighters. These employees then subsequently both filed unfair dismissal claims with the Fair Work Commission. And in deciding these claims, the Fair Work Commission considered key issues, including the seriousness of the material posted and the connection between the employee's private social media use and the workplace. The issue of whether the employees, I'll just change my... The issue of whether the employees were also adequately educated on the company's social media policy was also contested in both decisions. Now, while Ventia had a social media policy, the Commissioner was highly critical of Ventia's training approach. In deciding Mr. Pelly's claim, the Commission ordered that Mr. Pelly be reinstated and found that his dismissal had been unfair because he had not received adequate training on Ventia's social media policy. Ventia's training regime was delivered via online-only learning, and it was self-directed. And these factors meant that the Commission was of the opinion that this training did not deliver the same educational outcomes as face-to-face tuition, especially because it was over 100 slides in length and was viewed at a self-directed pace. Also relevant was the fact that Mr. Thompson's posts were, Mr. Pelly's posts were in the private Facebook group. They didn't mention Ventia by name, and they weren't the majority of these posts weren't made during business hours. And this meant that the Commission was satisfied that Mr. Pelly's conduct was not serious enough to warrant his dismissal. In contrast, the Commission held that Mr. Thompson's dismissal was not unfair, as he had viewed and distributed pornographic material during working hours, and this was serious enough to justify dismissal. This was the Commission's decision, regardless of the fact that Mr. Thompson had received similar online-only training on Ventia's workplace policies. Now, while the conduct of these two employees might sound like it would be sufficient to terminate their employment for misconduct, these cases provide a reminder to ensure that employers have clear policies on issues like acceptable social media use and have clear codes of conduct to clearly communicate expectations to employees. Employees should also be thoroughly trained on these policies and expectations to minimize the risk that the dismissal of an employee for misconduct and for breaching these workplace policies might be deemed unfair due to a lack of adequate training. This brings me to the end of the employment law segment of today's webinar, and I will now pass over to Jeremy.
Thanks, Olivia. Good afternoon to everyone watching. My name is Jeremy Bowden, as Olivia just said. I'm an associate at Hunt & Hunt. I work primarily in the criminal law space and do a lot of prosecutions for various regulatory bodies across New South Wales. I'll be taking you through a couple of the criminal cases that I found interesting or a little bit unusual in 2023. And I'm going to start with one that's actually a bit sad. This case here, which I'm just going to slide through. It doesn't. There we go. So the first case I'll be looking at involves a gentleman by the name of Nicholas Parker. Nicholas was, Nicholas was driving to work in a small country town at about 5 a.m. when he fell asleep at the wheel. In doing so, he veered off the road and collided with two cyclists and killed them. Parker was charged with a number of offences, including 2 counts of dangerous driving and 1 count of negligent driving causing death. The defendant pleaded guilty to those charges, and the matters were heard in the district court. In the district court, having pled not guilty, Parker was found not guilty of the negligent driving charges. He was found not guilty of the dangerous driving charges, but was found guilty of the negligent driving charges, and he was sentenced to 12 months imprisonment to be served by way of an intensive corrections order. The reason for the conviction was that it was held by the court that the defendant was not in a fit state to drive and that he ought to have known that he was at risk of falling asleep. Parker appealed the negligent driving conviction to the Court of Criminal Appeal. The appeal was ultimately successful and Parker was acquitted, with the court finding that there was evidence that Parker had spontaneously fallen asleep without forewarning. This helped the court conclude that Parker committed an honest and reasonable mistake, which is a defence to offences of strict liability. So this case is just another example of the legal defence of honest and reasonable mistake. It's an example that this defence is available even when the circumstances are tragic and even when the circumstances are so that people die. Effectively, this means that actions committed involuntarily or without conscious awareness may not be deemed criminal as long as you acted reasonably in the circumstances, even though to the general public, those actions are considered to an extent criminal. The second case I will take you guys through, it's a bit more lighthearted. It involves a local court magistrate who we're actually quite familiar with, Magistrate Prowse. Magistrate Prowse presided over a matter in the local court where his conduct was later criticised heavily by the Supreme Court. To paint the picture, Magistrate Prowse, he picked up a matter that had been adjourned previously by several other magistrates. On the 15th of September last year, Magistrate Prowse, having picked up the matter, agreed to a final adjournment. He agreed to that adjournment strictly on the basis that he would not grant any further adjournments when the matter ultimately returns to him. The matter returned to him on the 26th of October, a month later. And to no one's surprise, a further request for an adjournment was made. The request was made jointly by both the prosecutor and the defendant. Magistrate Prowse stuck to his word and refused the adjournment, despite the adjournment having been requested because the prosecutor and the defendant were in the midst of ongoing plea discussions. So, having refused the adjournment, Magistrate Prowse requested that the defendant enter pleas. The defendant's solicitor indicated that the defendant is not in a position to enter pleas, noting the ongoing plea discussions with the prosecutor. And despite having said that, or despite having heard that from the defendant's solicitor, Magistrate Prowse proceeded to enter not guilty pleas on behalf of the defendant in respect of 5 separate charges. 3 of those charges which were indictable offences, which were then to proceed in a district court. So this is where it gets interesting. In the local court, when Magistrate Prowse refused the adjournment and entered these not guilty pleas on behalf of the defendant, he made several scathing comments about the legal process at large, the EAGP scheme, and judges that actually sit in superior courts. Magistrate Prowse was led to a particular judgment by the DPP prosecutor on the day. That judgment was a judgment from Justice Kirby. In response to that case being raised by the prosecutor, Magistrate Prowse said this, and I quote him verbatim: "I don't think Justice Kirby or Justice Yahya or Justice Baston have ever been met with reality on the ground in relation to these sorts of matters, so as to infer that these justices haven't the experience in the local court or in the inferior courts." Magistrate Prowse then went on to say that he intellectually, fundamentally disagrees with Justice Baston in the matter that was delivered yesterday or the day before. For some context, Justice Baston is a former Court of Appeal judge who continues to serve as an acting judge of appeal. Magistrate Prowse proceeded to tell the parties that he had nothing to do that day except watch a Champions League football match, which was due to start the next day, indicating to the parties that he was there all day and he would be there until the matter was finalised. Unsurprisingly, the matter was appealed. Specifically, the decision to refuse the adjournment was appealed, and the decision of Magistrate Prowse to enter not guilty pleas on behalf of the defendant. The Supreme Court found, again unsurprisingly, that Magistrate Prowse erred in his conduct and didn't act in the interests of justice. The Supreme Court themselves made some scathing comments of Magistrate Prowse, including a comment that Magistrate Prowse made a number of highly inappropriate remarks which had the tendency to disparage judges of the court. Further, the Supreme Court commented that it is not the place of a magistrate to say he intellectually, fundamentally disagrees with a superior judge. The Supreme Court also concluded that His Honour's conduct brought the court system into disrepute. I guess this is a timely reminder to people like myself and other people in the legal profession in particular, and even lay people, that we are in a common law system. We are ultimately bound by the decisions and the judgments of superior courts. And whilst you may intellectually, fundamentally disagree with those decisions, we do need to exercise caution in airing those grievances or disagreements, especially in the context of being in a local court or an inferior court. You never know when those transcripts are going to make their way to judges in the Supreme Court or in the Court of Appeal. Who knows? It could even end up in the judge's hands that you so criticise. Third and final case I'll be discussing is one that might be of practical relevance to some, perhaps. In this case, an individual, the accused, was a co-tenant under a residential tenancy agreement alongside his partner at the time. The accused and his partner separated during the course of that tenancy agreement or of that lease. They separated in about May 2019. At the time of separation, there was still about 2 months left on the lease. And the accused left the apartment and stopped contributing to the rental repayments. So a short time later, in July 2019, while the lease was still ongoing, the accused turned up to the apartment and demanded to be let in. His ex-partner refused him access. The accused proceeded to kick the door open, damage the door. He then grabbed his ex-partner, shook her in what was described as a violent manner, grabbed her mobile phone and threw it at the floor. So the accused was charged with the accused was charged and prosecuted for breaking and entering. The district court heard the matter and found him not guilty, as on the basis that he remained a tenant at the time and he had a contractual right to enter the premises. So the Crown, again, unsurprisingly, they appealed to the Court of Criminal Appeal. They allowed the appeal and concluded that the accused didn't have consent or permission to enter the premises. This was then appealed further by the accused to the High Court. The High Court allowed the accused's appeal, meaning that they agreed with the accused, and they found that the accused couldn't possibly have committed a break and enter, considering he didn't trespass. The High Court found that he had a right of occupation under his lease, meaning a trespass could not have materialised. So the accused in this case was ultimately found not guilty of breaking and entering, but be warned, this isn't a green light to destroy property or to assault anyone, because rest assured, the accused was separately charged with assault, intimidation, and destruction of property, which understandably he pled guilty to. So that concludes my portion of today's presentation. I'll now pass you guys on to Katarina for her part. Thank you.
Jeremy. So as just mentioned, I'm Katarina and I'm a lawyer here at Hunt & Hunt in the estates team. So I will be discussing one estate matter that has some unusual facts. So there we go. So unfortunately, death is a reality of life, and after a loved one passes, some things can become somewhat messy and complex. The most common form of estate litigation is a family provision claim, which some of you would be kind of aware of it as it exists, contesting a will. It requires a person making the claim to be an eligible person, which there's certain categories under law, and they include a spouse, a de facto partner, or a person living in a close personal relationship with the deceased at the time of death. So the case I'm going to share with you involves a family provision claim in an alternative claim, with the primary claim being that the de facto partner of the deceased the plaintiff wanted a grant of administration of the deceased estate. This was contested by the defendant being the deceased sister. So the case is a case of star-crossed lovers, if you will, in the matter of Sheen and Hassan and the estate of Zahir. And we set our scene in Sydney, Australia. Mohammed Bashir Zahir and Winnie Sheen were in a very private relationship for some 13 and a half years, and it developed into a de facto partnership since about 2015. So on 16th of July 2020, Mohammed was tragically killed when he was stabbed by a friend and employee. He was only 44 when he died, and he died without a will and without leaving any children behind. So he died intestate. With having died intestate without any children, his partner Winnie, if she was found to be his spouse at the time of death, would have been entitled to the whole estate, or a substantial amount of his estate. So this case wasn't that simple. And the complexity lies in that they had a very private relationship that was kept from both of their families. So some background on them as individuals. Mohammed was born in Afghanistan and moved to India as a teenager with his family, and he was raised and remained a very devout Muslim. In 1999, Mohammed moved to Australia and commenced employment as a security guard and later the building manager of an apartment complex in Pyrmont, where he lived on site. And Winnie was born in South Korea and arrived in Australia in 2005 on a working holiday. In the years to come, Winnie chose to remain in Australia because of her relationship with Mohammed. Winnie had been raised in a Christian cult known as the Temple of Tabernacle, and from her experiences in this religion, she'd become disenchanted with religion altogether. So Mohammed and Winnie met in 2006, and they met again in 2007 when their relationship commenced. And in July 2015, the plaintiff moved from Maroubra to an apartment complex in Pyrmont, where she lived with Mohammed in the units. So for cultural reasons, Mohammed and Winnie felt that they had to keep their relationship private and hidden. Both feared that their families, with their different cultural and religious views, would disapprove of the relationship. The court found from the evidence that Mohammed had compartmentalized his life for a prolonged period and kept his relationship with Winnie a secret and isolated her from his family and friends. Mohammed believed that to be open and public with his relationship would bring disrespect to his family or bring shame to his community, where he perceived himself as a leader. And Mohammed's sister, the defendant, put on evidence disputing the existence of the relationship between Mohammed and Winnie. Mohammed, the deceased, had 8 brothers and sisters, and none of them really knew of the relationship between Mohammed and Winnie, or of Winnie at all. And so they contested her claim that she was his spouse. And Winnie put on evidence that included text exchange, Mohammed meeting some of her friends, and they took various holidays around Australia together as well. The court took this into consideration, and as well as some other aspects being their living circumstances and the intimate and sexual aspect of the relationship, and also some financial aspects as well. So ultimately, Winnie's claim that she was Mohammed's de facto partner at the time he passed failed, because the court found that though there was a de facto relationship between them from July 2015, ultimately it had broken down just prior to Mohammed's death. So the breaking point for Winnie was when Mohammed forgot her 40th birthday in early July 2020. It was a significant milestone for her and their relationship, as they were going to consider more seriously marriage and children. And when her birthday wasn't acknowledged, she ended the relationship, which occurred just 2 weeks prior to Mohammed's death. So though she was unsuccessful in the application for administration of the estate as the spouse of, or the de facto partner of Mohammed, her alternative claim in family provision was granted. She was found to be an eligible person based on her previous relationship with the deceased. And as such, Justice Hallen made a provision claim of 15% of the distributable estate. So Muhammad had an estate of about just over $3 million, and she was awarded $530,000. So, though not a typical set of facts, this case is a good example of the court analysing characteristics of a relationship to determine whether or not they were a de facto partner or a person living in a close personal relationship with the deceased. And this case shows that oftentimes contesting wills and making claims against the state can be emotional and messy and complex. And it's important that you get clear and comprehensive advice on circumstances of your claim, which is something that our firm could help with if it was ever a situation that you faced. That's all for mine, and I'll hand back over to Tyrone.
Thanks, Katerina. That was quite an interesting case, to be honest. Last section is we're going to quickly discuss unfair contract terms. The reason why we put this in is that there's new legislation that's been updated that imposes penalties for any unfair contract terms. So the big point here is it might be worth us having a look at some of the contracts that you have in place, just to make sure that there is no unfair contract terms in place, because they might need amending. Many businesses have standard contracts or standard service agreements in place that they obviously utilize on a daily basis or weekly basis and send out. And they might need just to have a quick look over by us just to make sure that they don't contain any imbalances for the parties. We're going to give a few quick examples of currently what's on the go. And this is the first instance is ASIC versus PayPal, where PayPal has a provision which states that basically gives 60 days to a consumer or a provider or whoever's entered into the contract to pick up any discrepancy in fees that have been charged. If they don't, they won't be entitled to claim the discrepancy balance. And basically, there's an imbalance in the parties' rights and obligations in terms of this provision. The next one is ASIC versus Auto and General Insurance Company. And once again, it's based on the contract and the unfair balance. It basically states in this term that consumers must notify Auto and General Insurance of any changes in their home or any changes that would materially affect or maybe not even materially affect their contract with Auto and General. What's unfair about the obligation is that it's unclear, and customers don't actually know whether they're practically meeting this obligation or not. And it gives Auto and General a broader right to refuse the claim or reduce any amount payable under the insurance contract. And it could mislead or confuse consumers or customers of what the actual true obligations are under the contract. The next one is HCF. And once again, it's a unfair contractual term, which deals with a pre-existing medical condition. And it basically gives HCF the right to deny any coverage to the customer, even if the customer wasn't aware of a pre-existing medical condition. And obviously that's completely unfair. So it'll be quite interesting to see what happens there. If there's any questions, no questions have come through, and I apologize, I should have said that at the beginning of the webinar. Please feel free to contact us. Obviously, Hunt & Hunt provides a wide range of legal services, everything from commercial to criminal to estate to IP. We've got experts in every field. So if there is any questions, feel free to contact us. Our contact details will be provided anyway. We'll send a separate email with the presentation and contact details. You're more than welcome to contact any of the experts that have spoken today or any of the other experts in other fields, because obviously we're limited on time and we can't cover every legal area that we provide services to. Hopefully next year when we do a recap of the best cases, we can include some of the other areas of law that we provide. And we thank you for joining us today. I hope it was insightful and I hope we provided some interesting cases. And thank you again.